Mr. Speaker, last week the Prime Minister stood in Parliament and agreed to immediately flow the $155 million shortfall in child welfare. But Cindy Blackstock's already saying she may have to take this government to court because they're stonewalling. Meanwhile, we have communities that are struggling with serious allegations of sexual abuse. Without the resources on the ground, there's no way to protect these children. This is money that is urgently needed. So this is about the credibility of the Prime Minister's word. Is he going to flow that money, or is this going to be just another in a long line of broken promises to Indigenous kids in Canada?
Great. Honourable Minister of Indigenous and Northern Affairs.
Mr. Speaker, we take the Tribunal's ruling very seriously, and we took the vote in the House of Commons very seriously as well. As you know, we've committed $635 million to address the funding gap, and we've committed to overhauling the child welfare system. The issue of child abuse is very serious, and it is going to be increasingly important that we talk openly about this and have First Nations leadership deal with this in a way that we can share this and deal with the 80% of addictions, 80% of incarceration attributed to child abuse. This has to stop now.
Mr. Speaker. Merci, Monsieur le Président. I rise today to speak at second reading of Bill C-92, an act respecting First Nations, Inuit and Métis children, youth and families. Ce projet de loi, c'est très important et je suis fière d'être ici ce soir de parler de ce sujet tellement à jour. There can be no doubt that Canada's child welfare system is broken, most especially when it comes to the issue of Indigenous children, who make up the vast majority of those who are in care or receiving child protection services. In my home province of Alberta, almost 70% of the kids who are part of the child welfare system are First Nations, Métis or Inuit, even though Indigenous children and teens represent only 10% of Alberta's total youth population. The province's troubled track record in the care of these children has been deeply disturbing, especially when it comes to the deaths of children and youth who were supposed to be receiving protective services. Between 1999 and 2013, a total of 741 young clients of Alberta's child welfare system died while in the care or under the watch of the province, and the vast majority of those who died were Aboriginal. That number is shocking for two reasons. First, it represents the snuffing out of 741 young lives that were meant to be in our care. What makes it worse is that successive Alberta governments covered up those deaths for years and years. Between 1999 and 2013, only 56 of those 741 deaths were ever reported or recorded publicly. It took a multi-year investigation and a legal battle by my former newspaper, the Edmonton Journal, to force the government to admit that the total number of fatalities was actually 741. And since then, almost 200 more children in care have lost their lives, an average of 22 deaths a year. Now, some of those deaths, of course, were unpreventable. Some of those children died of natural causes, of everything from childhood leukemia to complications after heart surgery. Others died in what you might call blameless accidents, a car accident, say, where the caregiver was absolutely in no way at fault or responsible. But far too many of Alberta's lost children died because of the negligence or, frankly, the malice of their caregivers, whether those caregivers were foster parents, biological parents, or family members providing guardianship through what is known as kinship care. Alberta is the province whose sad child welfare history I know best, because I spent decades as a reporter covering this very difficult file, working hard with my colleagues to uncover stories that governments wanted to keep hidden. But I fear there is no province in Canada that has a stellar track record when it comes to the protection and care of Aboriginal children. Our status quo is woefully, fatally broken. And for that reason, I am cautiously, very cautiously optimistic about the promise of C-92, which holds forth the promise of a new paradigm for the delivery of child welfare services, one that puts agency back into the hands of Indigenous families and communities. For far too long in this country, Indigenous children have been removed from their homes and their communities and placed into care without overmuch regard for their culture and sense of identity. Once we did it through residential schools. Now we do it through foster care. Now, not everybody would be comfortable with calling the results cultural genocide, but it is surely beyond debate that taking children from their families to be raised in non-native foster homes and group homes has all too often had the effect of depriving children of the chance to grow up with their traditions, their languages, their spirituality, their pride in their roots and their history. About 20 years ago, Alberta began to grant delegated authority to some First Nations to run their own child welfare systems. The experiment had some difficult and sometimes tragic outcomes, especially in the beginning. Some of those delegated child welfare authorities were, to be blunt, set up by government to fail. They were underfunded, they were under-resourced, they didn't have the trained and experienced staff or the practical capacity to deal with their complicated and demanding caseloads. And children died as a result. One of the chronic issues, which 20 years later still persists, is that Ottawa has always funded child welfare services on reserve and not the province. And in Alberta, that creates a significant funding differential. Banned welfare agencies for decades have received less money to do the same frontline work. And worse yet, they have been particularly shorted when it came to funding for preventative services, the front-end social supports that might have allowed struggling parents to retain custody of their children and helped families to thrive healthy and intact. So when I first read C-92, I was hopeful that this new framework, which would give even more direct jurisdiction to First Nations and Métis and Inuit communities to run their own child welfare agencies, would right that balance and give the communities the resources they need and deserve to care for their own. The resources, in fact, which the Canadian Human Rights Tribunal has previously ordered that they have. And hence the very cautious caution of my optimism. When this bill goes to committee, I believe it is essential that the committee make clear that if there is no firm promise of funding, then this new framework will remain just that, an empty frame, a flimsy false front building without walls or floors or ceilings. We can't just promise Indigenous Canadians self-governance of their own child welfare systems without guaranteeing unto them the money and the other resources necessary to do that job. This can't just be a form of words. A framework with an explicit funding commitment attached would be the most, without an explicit funding commitment attached, would be the most irresponsible of false promises. Mais je tiens à signaler une autre préoccupation particulière pour l'étude en comité. Le projet de loi C-92 accorde beaucoup d'importance en principe de l'intérêt de l'enfant concerné. Il va de soi que l'intérêt de l'enfant devrait être le fondement de toute politique de protection de l'enfance et de toute décision relative à la garde ou à la tutelle. But C-92 puts particular emphasis on keeping children within their extended families and within First Nations communities whenever possible. In fact, it validates and privileges one very particular form of family-based foster care, known as kinship care, above all other care models. And yet sometimes, if I may be blunt, sometimes kinship care is not in the best interests of a particular individual child. When it works, it can be a terrific method of care, an ideal way of minimizing disruption and dislocation in the life of a child. We can see that intuitively from our own family experience. But to be frank, I do worry that if we make kinship care the most favored default model of care, we could inadvertently put some children in jeopardy. Kinship care only works if there are proper checks and balances in place, if kinship care providers are properly screened and trained and supported. Too often I have written about cases where children were placed in kinship care because it was cheaper and faster than finding qualified licensed foster parents, be they Indigenous or non-Indigenous, or where the philosophical imperative to keep children with family members, including their parents, at all costs, actually cost the children in question their lives. I've covered cases that ended in truly horrific neglect, abuse, and death because kinship care providers didn't get the appropriate background checks or the necessary resources. And I've covered cases where children placed in kinship care died because social workers didn't follow up or even closed their files and walked away. That's not to say kinship care can't work. If the caregiving family members are properly prepared and get the ongoing support they need, it can indeed be the very best model, a paradigm for care that keeps families united and keeps children in touch with their relatives and their roots. It can reduce social and cultural alienation and give kids a badly needed sense of emotional stability. But real, robust, ongoing support is essential. And thus I would ask the committee members to consider the practical life and sometimes death consequences of defining kinship care as the automatic first best option. Sometimes because of intergenerational trauma, there is no one in a child's birth family who is able to provide the care that that child desperately needs. And sometimes a child who has been in care has bonded already with a foster family. and moving that child would deny them the security of remaining with the only adult caregivers they know, remember, or love. Let me be very clear. I would be the last person to say that the model of plucking Indigenous kids from their reserves or Métis settlements or neighborhoods and putting them into non-Aboriginal foster homes and group homes is a good one. And while I've covered horrific cases of children who died in kinship care or after being returned to their parents, I've covered many cases too of children who died at the hands of non-Indigenous foster parents, many of whom were also not adequately screened or trained or supported or monitored. As I've said, the system we have now is fatally defective. We need a new and better model for caring for children at risk and for caring for Indigenous families. Je souscris de tout cœur au fait qu'il faut donner aux collectivités autochtones les droits fondamentaux qu'ils n'auraient jamais dû perdre, à savoir leur droit de diriger leur propre système de protection de l'enfance et de prendre soin de leur. Ces droits auraient de leur être restitués depuis au moins un siècle. Je suis tout à fait d'accord pour dire qu'il nous faut des cadres et des écoles pour qu'une telle autonomie gouvernementale soit possible. Mais assurons-nous que les collectivités autochtones, métisses et inuites disposent des ressources dont elles ont besoin pour que leur autonomie gouvernementale fonctionne. Let me lean on the framework metaphor yet again. When you lay down rebar, when you frame a house, you have to start with a solid foundation, and you can't cheap out on your materials. So let's get this framework properly built. Let's ensure that the best interests of children really are put before the jurisdictional squabblings of politicians and government agencies. Let's make sure that we do everything we can to give the next generation the start it needs. And I ask us to do so in the names of Corvette Cryer, Jaylyn Cardinal, Traislyn Starlight, Shalena Arcon, Serenity R, Caleb Merchant, Jay Johnson, and all the hundreds of Indigenous children who have died because the care we and the status quo provided fatally failed them. Thank you.
right, thank you, Mr. Speaker. Another session, another missed opportunity to pass Serenity's law. Near the end of the fall session, when everyone agreed more action was needed to protect children, I suggested a minor legislative change that would require adults to contact police if they know a child is in need of intervention. In December, just before the session ended, this NDP government said, that's a great idea, but we've run out of time. Minister, what is your excuse this time? And don't say you're waiting for the panel to bring it forward, because you have already ignored most of their recommendations.
The Honourable Minister of Children's Services.
Thank you, Mr. Speaker. And Mr. Speaker, I'm actually very thankful for the work that the panel did, prioritizing vulnerable children and working together to come up with consensus recommendations. And Mr. Speaker, I'm very proud to have accepted and I'm moving forward with implementing every single one of them because, Mr. Speaker, this issue is so important that we all need to come together and rise above politics and figure out what is in the best interest of our children. And from that perspective, Mr. Speaker, I'm very excited to hear what the panel comes forward with after the second phase, and I look forward to working with them on implementing those recommendations as well.
First supplemental.
This bill is called Serenity's Law because there were adults who knew that little Serenity was in danger and did not call the, quote, director, unquote. And given that it could easily be called Ezekiel's Law, Ryan's Law, Alex's Law, because each of these children suffered long, neglectful deaths. And adults other than those found responsible for their deaths knew about their suffering. Minister, you have not introduced legislation that will take immediate action to save children's lives, as you promised that you would do. But there is still time. Will you bring forward Serenity's Law before this session ends?
Honourable Minister.
Thank you, Mr. Speaker. Mr. Speaker, once again, for the first time ever, all parties in the Assembly are considering real, meaningful changes to the way that we protect children. So, Mr. Speaker, again, this is one idea that the panel can consider. But again, Mr. Speaker, as previously stated, we do need to engage with police and others who would be involved by this. In the meantime, I would absolutely encourage every single Albertan to just know that you're legally required to report child abuse. And if you do know of an imminent threat to a child, please call 911.
Second supplemental.
Given that I have consulted with experts in health and safety law, police, legal counsel, people who work with intervention system, parents who have lost their children, and given that Serenity's family came to legislature to provide powerful personal support for the immediate passing of this law, and given that if I could, I would introduce Serenity's Law today. Minister, unfortunately, I'm not in a position to take this action, but you are. Why are you choosing not to do this?
Here, here. The Honourable Minister.
Thank you, Mr. Speaker. And Mr. Speaker, absolutely, we are all committed to moving forward in terms of supporting vulnerable children in this province. So absolutely, Mr. Speaker, I'm looking forward, with tremendous excitement to hearing the outcome of the work of the panel as they move through phase 2 to talk about how we can improve the child intervention system in this province. But again, I would state, Albertans, it is your obligation to call and report child abuse should you know of it. If you know of a child who's at risk of abuse or being abused, please report that. And if there's an imminent threat, please call 911.
Terrifying, scary, sad, everything.
4.5 years after Serenity died, her mom is holding vigil outside the courtroom.
As any parent would for their children, I wouldn't miss it for the world. I'll sit outside that courtroom every day, all day long if I have to.
Serenity was 4 years old when she arrived in hospital with a head injury. She died soon after. Doctors found she was malnourished and bruised.
My loving, wonderful, beautiful daughter, I think of her as one of my hugest lessons in life, and I hope that her death will be a lesson for everybody that failed her also.
The little girl had been living with family members designated through the Kinship Care Program. Now they're in court for a preliminary inquiry, charged with failing to provide the necessaries of life.
Serenity would be here today if we had more laws implicated for children. But I think she deserves justice.
Guardians of the children agree the motorcycle club is helping Serenity's family navigate the court proceedings.
They call us for support. We go to court with them, we give them strength, we sit beside them and make sure that they're okay.
The accused cannot be named to protect the identity of Serenity's siblings. Now 10 and 11 years old, they'll take the stand during the trial as witnesses.
It's surreal. Everything that we've been through in our journey as a family, it hurts. But I'm grateful that we are standing together as one.
That they were fine. And they kept them there. And I complained numerous times to everybody.
After Serenity's death, nothing was made public for years. The province didn't provide RCMP an internal report until fall 2016. Eventually, Serenity's story prompted the creation of a child intervention review panel. The Children's Services Minister confirmed children were still in the home of the accused. Meanwhile, Serenity's family campaigned for justice for Serenity. Today, her parents say they received some form of it.
I was happy and I was disappointed at the same time. There was also other things that happened to Serenity, so I was just wondering if they were going to be charged for those.
RCMP say no further charges are expected, and the ones that were laid match the evidence gathered. They are not releasing Serenity's official cause of death. Have been released from custody with conditions. They are scheduled to appear in Wetaskiwin Court November 9th. Daryl, RCMP say they are no longer have any children in their care.
What's happening with the review panel, then?
Oh, it's still going. According to a government website, the panel has met nearly 24 times since it was launched this past February. The next meeting is scheduled for October 16th at Edmonton's Federal Building. The panel is expected to submit recommendations later this year to, quote, strengthen the child death review process.
Right. Dan Grummett joining us live in studio tonight. Thanks, Dan.
After announcing long-awaited charges in the case of a 4-year-old girl who died in government care, RCMP have added a clarification.
In a press release issued late last night, Mounties say the single joint charge against Serenity Rabbit's caregivers has nothing to do with the toddler's death. Rather, it's in relation to her living conditions while she was alive. The update is adding frustration for Serenity's parents who already believed the lone charge did not go far enough. With more on this, we're joined live in studio by CTV's Jeremy Thompson. Jeremy, you had a chance to speak with Serenity's mother today.
I did, and guys, for Ashley Rabbit, this whole process has been frustrating. She believes Serenity's great aunt and uncle should face more serious charges and can't understand why no one is being held accountable for her daughter's death. A report from Alberta's Child and Youth Advocate Office found after 2 years living with her great aunt and uncle, Serenity Rabbit had gone from playful picky eater to undernourished and covered in scratches and bruises. In fall 2014, the toddler was admitted to hospital with a fractured skull. She died a week later. Friday, after a year-long investigation, RCMP announced a single
have been charged jointly with one count of failing to provide the necessaries of life.
5 hours later, a clarification from police. The joint charge has nothing to do with Serenity's death, only her living conditions. RCMP wouldn't say what killed the toddler, only stating the injury was not criminal in nature. It's the latest blow for mother Ashley Rabbit.
She wouldn't have survived anything if any kind of accident would have happened because of the neglect that led up to her death.
The 2016 review into Serenity's death says a caseworker visited the Rabbit's home after concerns were raised about the well-being of Serenity and her 2 siblings. Child Intervention Services launched an investigation. The end result saw the children stay put. And later that month, the accused were upgraded from kinship caregivers to private guardians.
The government's too scared to charge their own social workers because they don't want to take responsibility. Well, I've taken responsibility for my actions. I have to live with it for the rest of my life.
Rabbit also can't understand why no charges have been laid in connection to her other children raised in the same conditions.
The only difference is that they survived. Everything that happened to them is okay with the justice system. It's okay with the police.
RCMP would only say that they are confident that the charge that has been laid has enough evidence to get a conviction in court. The co-accused will appear in Wetaskiwin next month.
All right, Jeremy, what is the province saying about this? Has anyone commented on the charge?
Well, the Justice Minister put out a statement after yesterday's conference, but before the clarification from RCMP. She says, in part, the professionals in the RCMP and Alberta prosecution with the Crown Service have been working directly to ensure their investigation has carefully and thoroughly considered all avenues.
All right, CTV's Jeremy Thompson reporting live in studio. Thanks.
Thank you to all who contributed their time and effort in helping towards passing Serenity Law, the first child abuse law in Alberta, Canada. Also thank yous extend to all friends, family, supports of Serenity's justice including, Honorable Mike Ellis, Paula Simons, Governor General Mary Simon and MP Charlie Angus, Honorable Cindy Blackstock, Ashley Marie, Jimmy Joe, Linda, Keri Whitebear, Jakob Tambour and their family would like to express their greatest gratitude to all of the elders who took part, including, in Khukum Kathy Hamelin and dear friends Wendy Robinson, Kuna Sauve, Alfredine Linda Plourde, Velvet Martin, Tabetha Dolan, Sharon Lafferty, Jamie Rogers and her mom, Laura Poulton, Amander Meadow Arrow-Maker, Karleena Perry, and Clint Goodrich, who is the president of the Urban Bulldogs Against Kids Abuse from the Wetaskiwin Chapter, and to our friends and approved photographers/videographers/publishers. Carolyn Martins and Max Putzier. From Calgary, Alberta, Trevor Dewering, Tabby Sabo, Norm Average and Chaz Smith from Be The Change YOIC. Also thank you to the drummers and MC, Leonard Saddleback, and Wayne Adams for the captured footage of Serenity's first Memorial Round dance, Boyle Street Plaza, our sponsors, Value Village, Goodwill and Smitty's Family Restaurant and many others who supported this journey. So many more! Words cannot describe our gratitude. In Alberta, Serenity Law was created as Bill 202. It was passed October 30th, 2019. Without your help along the way, Serenity Law couldn't have been achieved. This could have not been done without all of you. In Alberta, Serenity Law Bill 202 consists of: if a person does not report child abuse to authorities in child welfare, that person can be held liable, charged up to a $10,000 fine and up to 6 months in jail. Helping save children, eventually, nationwide. Serenity Law. Samantha Law. Every child matters.
Timmins, James Bay. For 7 months, the body of 16-year-old Devin Freeman hung on a tree 35 meters from the group home where he disappeared, and nobody found him. What a sad symbol for this nation. First Nation families are losing their children all the time to what the Human Rights Tribunal has ruled the willful and reckless discrimination and systemic underfunding by this government. So to this Prime Minister, stop with the honey-dripped words and call off the lawyers. Will he commit to meet with Cindy Blackstock to ensure that the Human Rights Tribunal ruling is respected so that no more children die on his watch or our watch?
The Right Honourable Prime Minister. Mr. Speaker, we strongly agree that survivors, that we must compensate Indigenous children harmed by past government policies. We want to ensure that Indigenous people harmed under the discriminatory child welfare system are compensated in a way that is both fair and timely. We want to work with all parties to address this issue. We've demonstrated our commitment to addressing long-standing child and family service needs of First Nations, Inuit, and Métis children.
husband. She is the mother of the year of Alexander, but for all of Alberta who's here with us today. See, these are both ceremonial women here. They know how important it is about raising children, about prayer, asking the holy, blessed Virgin woman out there for that special prayer for the woman, the lost, and the memorial service. As an MC also, I remind all the people that are MC, when there's a service, once the song goes, you don't keep talking more. That's what I was told. Once the prayer of the song is the drum in the heart of the beat of heaven and earth is inside the body and the mind, the heart, and the soul of the individual. It's our duty to go in there and dance and support a community event. You know, Keri worked hard for this. So is Kathy and the members that stand here. They worked hard for this. That's why it's important for all of us to acknowledge that. Respect of the Creator and Mother Earth. And respect the dancing mother of the Spirit that was given to the woman, the dancing woman of a holy angel. And us men, the dancing man. This the prayer that's going to be rendered here. They're going to ask that this woman continue this very special way. And this is the first annual. Usually it takes 4 years to do this. Sometimes only 1 year, and because they fulfilled they feel that's good, and that's okay too. But if you're going to continue ceremonial ways to teach other people, love your grandchildren, love them the best way that you can have, and enjoy them. When they come running to you, don't push them away. Sit down. Grab them. Hold them. This is my grandchild. This is my no-sim. Honor that. Because I've seen my wife, Julia, how she'll do anything for her grandsons. She'll do anything for them to be out of alcohol and drug-free. I've seen that from my wife. Takes care of her daughters. Even driving through, going from city back and forth, and they live in Devon, and we're going through. My wife always goes through and says their names and says, she sends kisses. Even during the night, we're going home in a 4-lane, Free Elizabeth Highway, going home. She looks at Devon. Sleep well, my children. And yet they're in their 40s and 50s, and she'll say, love you all. Have a good sleep. Are you hungry? That's what my Khukum used to do. My dad's mother. Her angel name was Kissed by an Angel. And she would say, wherever my kids are, say, I kissed them, just like when they were babies. She reminded me that, it's beautiful. With that, my sister-in-law, Mary Rose, Mother of the year 2000. Let's rise and pray for us. I hope. And you jobbers, do not hit the drum out there. Do not hit the drum. Absolutely no drumming while this event is going to take place. Why? Because the voice of this woman needs to be heard. So no drumming, no drum practice, please. Just sit down and don't do nothing in the middle until this woman got invited us. Let's have a great respect for the woman. Listen up.
over the years, we have fought very hard with our government to try and make change for children. I've been fighting for children's rights for 4 years now, and Serenity has come a long way. We have made change through her name with the first Child Abuse Act, which is called Serenity Law. It's Bill 202, which I'd like to say thank you to Mike Ellis, which he is not here tonight. I would like to thank him for helping the family and for going as far as we have. There's many things that we have overcome. Not only us being First Nations, not only us having a child welfare system. I've asked our governments to make change in the law for our children, and you have to understand that it is a long process, but we have come a long way. I'd like to thank each and every one of you for coming. It does mean a lot to me. And I'd like to say that I appreciate your support. You know, and we're still going to fight this. You know, I know that you guys know that we have been fighting for Serenity's justice for many years now. But it's not only for Serenity, there's many children out there. There's 881 families that are going through the same thing as we are. I'm sorry Ashley is not here, she couldn't make it. She's scared to fly, and everything that's going on in the news, she didn't want to fly here. But she does give you guys, each and every one of you, thanks for coming. And so does my son, he is here somewhere. But you know, I'd like to thank everybody that came, Northern Cree. Hey, Leonard. And Ephraim. But you know, I'd just like to say, you know, when we gather like this, it's for the children. We have to understand our children are going to be our future, our grandchildren are going to be our future. And that's why I fought so hard for Serenity. I fought so hard for Serenity because I realized there was more than just Serenity out there. And over my course of time in my work, I realized that, you know, if I can speak up and have a loud voice against our government and everything else to speak, then everybody else can. If we all come together as a community and together as one, we can all fight this. We can make change for our children. Because it is the truth. The future of ourselves are our children, our grandchildren. And this is what this is about. It's the future of our children. Thank you for supporting the families. And thank you for coming.
Yeah!
my granddaughter died in care at the age of 4. So with her death, we made the first child abuse law, Bill 202 for Alberta, which is consists of nobody that phones the police or child welfare for child abuse on any child in Alberta can get fined $10,000 and 6 months in jail because she died in care from child abuse.
That's right.
So when she died, we weren't allowed to talk for 2 years. We weren't allowed to tell you guys nothing. They put our family on a gag order. And by the time you guys found out, they already held her body at the Alberta Medical for 2 years before they released her back to us.
Wow, that's terrible.
And then in 2017, you have to understand, she died in 2014. In 2017, they finally charged them. But within the last 4 months, the charges were stayed.
Wow.
We may have got a child abuse law from her, but that's not enough. She deserves justice.
I'm sorry.
She was supposed. Today's the day she died, so she would have been 10 this year. And I appreciate your support. Yeah. Did you give her a blue ribbon? That's the memorial. Yeah. Those are tied wrong. Yeah, no, it's all together. It is. Yeah. But there's a Serenity Law ribbon.
Oh, there. Yeah. Do you want me to give you this?
No, you can have both of them.
Okay.
Yeah.
You know?
Yeah.
And,
I haven't given up.
That is a particular case. She deserves any change. If I had the law in my hand, I would make the change.
Thank you.
Prayers and energy is always needed. Thank you.
But I wish you the more than what you deserve, you know?
Thank you.
I wish you guys, because that child deserves more than what the whole world holds up.
Thank you.
And I'll keep that with me for a long time.
Thank you so much. You have an amazing rest of your day. Stay safe.
Thank you.
The numbers are startling and a sharp increase from previous years. From April of last year until the end of February, 45 young Albertans died while receiving government intervention. That's a record high compared to previous years. There were 34 deaths in 2020, 2021, and 33 in each of the 3 years before that. The report shows the increase is primarily in young Indigenous Albertans. 36 of the 45 deaths were Indigenous children, youth, and young adults receiving government intervention.
This is an issue. It's a very concerning number. It's not only a tragedy when a child who is or has been in care, but it's also a call to action. We have been looking into this. I asked the ministry to do a detailed report on what exactly we were seeing, because if there are changes that need to be made, we need to be able to make them.
It certainly is time for us to bring all of the ministries together to have a complex and fulsome discussion about how this needs to be resolved.
A statement from the Office of the Child and Youth Advocate says, yes, the numbers are increasing and more needs to be done. It'll be releasing another mandatory review at the end of the month. Kim Smith, Global News.
you.